bondsman, and the bondsman will walk you through what they want.
Okay.
All right, thank you. Okay. All right, Ms. Bashal, you can come in. And then Amaya Roberts. Hi, ma'am. Can I have your full name and date of birth?
Jessica Bashaw, April 15, 1978.
All right, thanks. You're hearing a warrant from the Pioneer Justice Court, which I believe is in Pinal County. And this is in an interfering with judicial proceedings case, also known as disobeying a court order. It's a misdemeanor. This warrant was issued March 11th of 2025, and it says failure to comply. So it's post-conviction. All righty. Your next court date is going to be March 25th at 8:30 in the morning. That's 5 days from now in the Pioneer Justice Court. That address will be on your paperwork. Your bond is $250. That is secured. If you bond out, you need to be in Santan Valley is the address. You need to be in Santan Valley in 5 days or you lose your bond money, and there'll be a warrant issued for your arrest. If you don't bond out, I'll let them know they should provide you a lawyer to represent you on the bond question only. So I appointed a lawyer only in case you don't post bond. If you do post bond, that lawyer is going to withdraw because you've already been convicted. So if you bond
What do you
out,
mean I've already been convicted?
this says post-conviction. Failure to comply is post-conviction. Are you in a diversion program?
This is, I don't know what this charge is for.
All right. Well, then you need to go talk to them because failure to comply is almost always something after you've been convicted, like DV classes, payment of fines, something like that. Sometimes if you...
My ex-husband moved to Pinal. Yeah.
If you're in a diversion program and you haven't been convicted yet, they can issue this kind of warrant because you're not complying with the diversion program. I don't know which your situation might be. You need to go to Pinal and talk to them. So it's $250 if you bond out. Do not miss your court hearing. If you show up at all your court hearings, you can get that bond money back.
Okay.
All right. If you step to your left, they'll give you...
How do I pay for a bond?
Talk to the DOs after court. They'll help you. All right, Ms. Roberts, Amaya Roberts, and then Tanya Galves. Will you please go to the chair? Hi, ma'am. Can I have your full name and date of birth?
Right. Amaya Roberts, March 12, 1999.
Okay, thanks. You're hearing a probation warrant. You're on probation for a Class 6 felony, and back on July 7th of last year, there was a petition to revoke your probation filed. It alleges that you violated terms 1, 5, and 6. You'll get a copy of it from your lawyer, and I am appointing a lawyer for you. Your next court date is a revocation arraignment of possible disposition hearing in the Downtown Superior Court. That is 1 week from today, which is Thursday, March 27th, 8:30 in the morning. The address is on your paperwork. Your bond is $500. It is secured. If you bond out, comply with all of your written conditions. Call your PO within 72 hours. The main number will be on your paperwork. And he's got that for you if you want to step to your left. Thank you.
May I have a question?
What's your question?
So when I was not read my rights, then I was arrested because...
That's actually not, everybody thinks that's a requirement for a legal arrest because they watch television.
No,
it's not, ma'am. I'll finish because you raised it. That is a requirement for interrogation. If they're going to use your statements against you at trial, you must have had Miranda first. So Miranda has nothing to do with the lawfulness of the arrest. They can arrest you when you're in a coma. They can arrest you when you don't speak the language. The reading of Miranda has to do with the admission of interrogation statements at trial. So you appear to have been legally arrested. Go ahead.
Yes, ma'am. Also, so I didn't see how I violated probation when I must have been when I had my number changed, but I did get in contact with Officer Flowers, and I did speak to her. I just didn't have a number for her.
You've been in warrant status since July, ma'am, and this is a weapons charge. So you have to post bond to be released again. Okay. This says absconded and unable to locate since July. And so they made no note of you contacting them, nothing.
My monthly check-in.
They will dispute that, I'm sure, because it's not in the notes. Okay. So you get a lawyer to help you defend against the accusation of violating. Right now, you will have to post bond for the court to trust you out in the community again.
Okay.
If you do post bond, immediately call your PO. You get 72 hours to do it. If you're smart, you'll call them right away because you are still on probation even when they're trying to revoke it. You're on probation. Okay. So if you bond out, do not fail to comply with probation between now And then, because you can be held no bond in this case, and if you're out in the community, something else happens, while you're awaiting the outcome of this, we will hold you without bond in this case.
Okay.
All right, if you step to your left, you get your paperwork. Good luck. Ms. Galvez, and then Ruby Gonzalez. We go to the chair. Hello, ma'am. Can I have your full name and your date of birth, please?
Yeah, Tanya Galves, July 15, 2002.
All right, thanks. You're here on a new case. You were arrested for criminal damage, a Class 1 misdemeanor, alleged as a domestic violence offense, which is a status, meaning there's a domestic relationship between you and the alleged victim. All righty, there is probable cause for this. I am appointing a lawyer for you. Your next court date is an arraignment hearing on April 9th at 9 in the morning in the East Mesa Justice Court. That address is going to be on your paperwork. You don't appear to have been arrested before, and in this case, I believe that it will be safe to release you on your own recognizance. You do have domestic violence type release conditions, though, and that includes you cannot go to the scene of the alleged crime. You can't have any contact with the alleged victim, who appears to be your mother. No weapons, no drugs, no alcohol. If she contacts you first, do not respond. Everything else is on your paperwork. Any questions? All right, you should be out within a few hours. Try to be patient. It still takes a few hours to be released. All right, good luck. All right, Ruby Gonzalez and then Leslie Crumry, will you go to the chair? Hi, ma'am. Can I have your full name and date of birth?
Hi, yes, Ruby Gonzalez, March 20th, 2000.
Okay, thanks. You're here on an arrest warrant. That means there's been a criminal complaint filed against you, charging you with a case from last year. Let me read it for you. All right, the charges are possession of narcotic drugs, a Class 4 felony, possession of drug paraphernalia, a Class 6 felony. The alleged offense date is January 6th of last year, 2024. And it looks like this comes out of the El Mirage Police Department. But if that doesn't ring any bells, you'll get police reports and a copy of the charges from your lawyer. I am appointing a lawyer for you. Your next court date is a status conference, April 3rd. That's in about 2 weeks, 8:30 in the morning in the downtown Superior Court, with a preliminary hearing April 7th at 8:30 in the same court. And you qualify for release on your own recognizance. You have not missed any court dates in this case. There were several attempts made to mail you a summons, but we didn't have a working address. So we don't hold that against you. That's the only reason this turned into a warrant. So I'm going to release you on your own recognizance. Just comply with your release conditions. Everything's in writing. Do not miss your court dates. You see what happens when people miss court dates. All right, if you step to your left, you get your paperwork, okay?
Thank you so much.
Take care, ma'am. Ms. Crumry and Valerie Lara, will you please come to the chair? Ms. Lara, to the chair. Thank you. Hello, ma'am. Can I have your full name and date of birth, please?
My name is Lesley Robin Ryan. My date of birth is 12/31/1970.
Okay, thanks. You are here on an arrest warrant that issued because there was a criminal complaint filed against you, charging you with possession of dangerous drugs for sale, which is a Class 2 felony, and possession or use of narcotic drugs, a Class 4 felony. Same offense date alleged for these. It is October 29th of 2021. So 3.5 years ago. It looks like this comes out of the Gilbert Police Department. That doesn't ring any bells. You'll get a copy of the charges and police reports from your lawyer. I am appointing a lawyer for you. Your next court date is a status conference April 3rd at 8:30 in the morning. That's in the downtown Superior Court. Preliminary hearing April 7th at 8:30. The court address is on your paperwork. And this is also an unserved summons, meaning even the county attorney just asked for a summons in the beginning, but we didn't have a working address. So you have not missed any court dates. We don't hold that against you. So you otherwise qualify for release on your own recognizance. It appears you have not been arrested for several years at least. So right now, I don't have any reason to think that you won't come to court and comply with release conditions. Your prior is pretty old. Yeah. And in a case like this, you very well might get some kind of probation offer, etc., if you want to consider that. I'm just trying to encourage you to go to court because a sales charge is obviously serious, as is any felony charge. But I am releasing you on your own recognizance because this is alleged from 3.5 years ago and you haven't missed any court dates. So just comply with your conditions. Don't miss your court dates, okay?
Yes, sir.
You step to your left to get your paperwork.
Thank you.
Ms. Lara, and then Mr. Nicholson, will you go to the chair, please? And then, officer, I'm going to want to actually clear after Mr. Nicholson, just so you know. Hi, ma'am. Can I have your full name and date of birth, please?
Valerie Maria Lara. 8/28/1982.
All right, thanks. You're on a new case. You were booked in for dangerous drug possession, a Class 4 felony, and shoplifting as a Class 1 misdemeanor. There is probable cause for those, and I am appointing a lawyer for you. Your next court date is a status conference, April 3rd at 8:30 in the morning in the downtown Superior Court with a preliminary hearing, April 7th at 8:30 in the same court, and that address is going to be on your paperwork, and I'm going to release you on your own recognizance as well. You don't have any felony priors, and these are not victim cases. So what I'm going to do is order you not to go to the scene of the alleged crimes. I think that was a target.
Yeah.
No contact with any witnesses there. No weapons, no drugs, without a valid prescription. Don't miss your court dates, okay?
Okay.
If you step to your left, you get that paper.
Thank you.
Thank you. All right, Mr. Nicholson? Hello, sir. May I have your full name and your date of birth, please?
Matthew McCall Nicholson,
What's your date of birth, sir?
February 1st, 1968.
All right, thank you. Mr. Nicholson, you were arrested on 3 allegations of driving under the influence of alcohol. It's basically, they've alleged 3 different violations of the statute based on the same offense conduct. That is, driving under the influence of alcohol or drugs while impaired to the slightest degree, DUI with a blood alcohol of 0.08 or more, and extreme DUI with blood alcohol of 0.20 or more. Those are all misdemeanors. The punishment differs depending on what a person is convicted of. Now, there is probable cause for all of those. And in your case, I have a few questions for you because I got not quite enough information from the police and pretrial services. Is it correct in your financial profile you work for DCS in Texas or in Arizona? Where do you work, sir?
We are putting in a new conveyor system for USPS at Fairway and I-10. I live in Texas.
Okay, but you're here on a long-term job?
Yes, sir.
All right, how long does that
Yes,
job
ma'am.
go?
Ma'am?
How long does the job go? Like, how long is your job done? You got a couple months to go? Like,
No, I've been here since January.
and when are you supposed to be done? When's the deadline?
Thursday.
Okay, so the job is supposed to be done this Thursday. Okay.
Yes.
All righty, that makes sense. And do you make about $18,000 a month?
Ma'am?
How much? What's your monthly gross income before any bills?
16,000.
Okay, all right. Then I cannot appoint a lawyer for you, well, because you're not indigent. But you have the right to hire a lawyer at your own expense to represent you. So you can also represent yourself if you don't want to hire a lawyer. But I'm not appointing one for you. Understand?
No, ma'am.
I am not giving you a court-appointed lawyer because you make too much money.
Yes, ma'am.
Are you having trouble hearing me?
Just a little bit. I have hearing aids.
Okay, let me have you shut the door. That kills the echo. I'm going to test this. We also have headphones. Have you seen this before? Okay. Okay, is that better, or would you like
Yes, ma'am.
headphones? Is this okay?
Yes, ma'am.
Okay, because we also have headphones. This is just easier.
Yes, ma'am.
Okay, I wasn't sure if you were cognitively impaired or you couldn't hear me. And when you said you made $16,000 a month, I thought you probably can't hear me. Okay, all right. So I'm not appointing a lawyer for you because you make too much money for
Yes,
a
ma'am.
free lawyer. What you have is the right to hire one at your own expense. You also have the right to represent yourself in this case at future hearings. Your next hearing is going to be an arraignment hearing, April 15th, tax day, at 1:30 in the afternoon.
Yes, ma'am.
This will be on your paperwork. The address is in the city of Surprise. Everything will be on your paperwork. Now, in your case, I am concerned about your blood alcohol level and your history of similar or adjacent type offenses. And so I am setting bond in your case at $1,000 secured, but I'm going to let you go back to Texas. So if you post bond, I'm going to let you go back to Texas. Arizona can and will revoke your license here, and that'll go into a national system if you blow this off and you don't come. So there can be very serious consequences anyway
Yes,
of
ma'am.
not showing up for these charges. But normally, we don't let people leave the state when they're facing criminal charges. But in this case, you don't have any felonies. You have a 2010 arrest in Texas, a 2001 reckless driving out of Washington, which very frequently, when you get that kind of a sentence, started as a DUI. And frankly, sir, a blood alcohol of 0.26, if that's what it was, is almost per se evidence of alcoholism. Alcoholism strongly indicates you might do this crime again and hurt or kill somebody. So the court takes all of that very seriously. That's the reason I'm posting a bond, I'm setting a bond in order to let you go back to Texas. I assume you're able to post this bond if you make that amount of money. The bond is intended to try to motivate you to come back in order to get that money. You can also call Surprise from Texas and ask about appearing remotely. They may allow that. I don't know what their rules are, yes, but it is 2025, and in a misdemeanor, if they want to allow you to appear remotely, they can. I don't have that power, nor would I make that decision on their behalf. Ma'am. What I can do is I can give you permission to travel until your next court date. So you have permission. How do you go to Texas? Do you fly or do you drive?
Drive.
Okay, that's what I figured. I was like, you have equipment, right? Okay, so I'm going to allow you to go to New Mexico and Texas. Were you planning to work anywhere else in the interim?
Not in the state
Between April?
Not in the state of Arizona.
Where else?
In Texas.
In Texas? Okay, you're fine. So you have permission, in this case, to be in Arizona, New Mexico, and Texas while the case is pending. That only goes to April 15th. Once you appear on the 15th, you can ask that judge for further orders. If you've got a job in Minnesota, you need to tell the judge, get permission to be in Minnesota, etc. And let me check. You can always Google the number for the Surprise Police Department. It's not on our paperwork, I'm sorry. Some are, some aren't. Just Google it. Sorry, not the police department, the court.
Yes, ma'am.
Call the Surprise Court and say, this is my case, this is my court date, how can I ask to appear remotely? So everything's on your paperwork. Do you have any questions?
No, ma'am.
All right, then as long as you post that bond, you're permitted to travel. You have written conditions. Those include no alcohol, no driving without a valid license, do not return to that Buffalo Wild Wings, don't have any contact with the witnesses there. Everything you need to know is on your paperwork, and I think we just need to reprint it so you have the travel permission. We will send it out to you. If you guys just wait by that door, they'll let you out.
Thank
All right,
you.
thank you.
Thank you, Your Honor.
You want me to clear out the court, ma'am?
Yeah. And let's go ahead and clear, and then I'm going to do Ms. Falanico's case. So go ahead and have a seat, ma'am. Ms. Falanico, sit down. Thank you. All right, so it looks like we're clearing pretty quickly. When they don't clear quickly, I do alcohol. Oh, yeah, I can clear. I don't use and so this is everybody's going out. All right, Ms. Falanico, you can go ahead and come in. We're clear, right, officer, between her and Mr. Fields? Okay. All right, ma'am, may I have your full name and your date of birth?
Shanat Falanico, November 15th, 1982.
All right, thank you. You're here on a new case. You're arrested for child abuse, a Class 4 felony, and disorderly conduct, a Class 1 misdemeanor. There is probable cause for both of those crimes, and I am appointing a lawyer for you. Your next court date is going to be a status conference April 3rd at 8:30 in the morning in the downtown Superior Court. That's about 2 weeks from now. Preliminary hearing April 7th at 8:30. And I'm going to follow the recommended supervision level for you, which is pretrial services supervision. I'm not making you post a bond, and here's why. The purpose of bond is to increase the likelihood of compliance with release conditions and court appearance. And in your case, right now, I believe you are reasonably likely to appear for court and comply with conditions. The court does not in any way mean that to indicate the court doesn't believe these aren't very serious allegations against you. I do believe they are very serious allegations. So for that reason, I am prohibiting, of course, any contact with the alleged victim. Even if he contacts you first, you may not respond. I gave some thought to the specific allegations in the case, and I will permit you to have contact with your other children only to the extent that it has not been limited or prohibited by DCS. So absolutely no contact with this 11-year-old. The other children, you today have permission to have contact with them, provided DCS has not limited or prohibited it. I don't know where your other children are. If DCS has removed them, then you are under the DCS order. But on these facts, the court believes it does not necessarily indicate violence toward your other children, just targeted violence at this one child. Many cases, there was one on the earlier calendar, I prohibited contact with all of that gentleman's children because his indications were that he was violent against many members of the family. The police allege that you have selectively been violent against this child. So on those facts, I'm not prohibiting contact with your other children, provided DCS has not prohibited it. Everything you need to know is on your paperwork. You're going to get an envelope. Call pretrial services when you get out. That envelope has all of your instructions. Don't lose it. Don't miss your court date. Don't violate release conditions. Okay? If you step to your left, you get your paperwork. You will be released in a few hours. Mr. Fields? And if we can clear her, officer, that'd be a good idea.
I'll be right back.
Is she like to know? Are they going to kind of get separated? Yes, the odds are really small. But if somebody was like, okay, and somebody hears it and they're like, oh, really a beat down on you as soon as I can know you just don't know what's going to happen. And sometimes so many people are like, comment this and you said you I always and so there's, there's such on these charges that you can use. And if that's the case, this is the hassle. So what I do is I say, and the police, because you were alleged to use the drugs in front of your kids, and I basically just say, and you don't listening, it isn't punching the children, it's children standing on the cross. But not what's going to and things like indecent exposure. I often know just take child that's a lot of times there's pain and kids living it. It's a bit different. Well, I do try. Okay, listen. Fields is a house call. Thank you. Thank you. I was like, because you can't see not half, you can't see, okay. He is a house call. Yep, I was not paying good attention. All right, so Officer, as for Jeremy Chinnon, Marcus Martinez, and Tyrone Fields, are they not physically present in court because they've been isolated as a potential risk of danger to themselves or others?
Yes, UTF and combative.
Okay, thanks. I did get a positive response from the Sheriff's Office, so I will conduct each of those initial appearances in person, in-house, immediately following this recording. Advise Jeremy Chinnon, born August 9, 1986, that he's before the court on a probation violation warrant. He's on probation for a felony, and on March 10th of this year, there was a petition to revoke filed alleging that he violated from 6, 7, and 11. I am appointing a lawyer for him. I'll let him know that his next court date is in 1 week, which is March 27th at 8:30 in the morning in the downtown probation court for a revocation, arraignment, and possible disposition hearing. And it's the court's inclination to set bail in this case in the amount of $250 secured plus written conditions that I will go over with him. Marcus Martinez, born 12/20/96, is before the court on a warrant from the El Mirage City Court. It is a violation of a written promise or notice to appear warrant, and it was issued March 19 of this year for an apparent failure to appear on March 11. All right, I will let him know I'm going to tell El Mirage to appoint a lawyer for him if he can't post bail. There's a arraignment hearing there scheduled for March 25 at 8 in the morning in the El Mirage City Court. And it's the court's intention to affirm El Mirage's bond at $75 secured that I will go over with him, in addition to his release conditions. Tyrone Fields, born 9/18/77, is here on a grand jury warrant because he's been indicted on one count of failing to register as a sex offender with an alleged offense date of 12/29/23, one count of sex offender failure to confirm ID, which is a Class 6 felony. That offense date, importantly, is May 20th of 2024. I am appointing a lawyer for Mr. Fields. His arraignment hearing is going to be March 27th at 8:30 in the morning in the downtown Superior Court. And based on the case information set forth in my formal order, it appears he was on felony release at the time the second offense was allegedly committed. So we're also setting a bail eligibility hearing for him the afternoon of March 27th at 1:30 p.m. And we'll go over that with him. And if anything changes after I conduct any of these initial appearances in-house, my final written order will reflect the court's ultimate decision in the case. It is not the court's intention to supplement this recording. And with that, we are going to stand in recess until 2 p.m. this afternoon.
All rise.
Thank you. You may be seated. Like Teams or something?
You don't have to.
Interpreter, can you hear me?
Good afternoon, yes. This is Jared Clark, one of the Spanish interpreters.
Thank you very much, interpreter, for being here this afternoon. My name is Commissioner Elizabeth Campbell, and we are here today on March 20th, 2025 for the 2 p.m. calendar. Initial appearance. Sorry, go ahead.
Mi nombre es la comisionada Elizabeth Campbell. Estamos aquí para las audiencias de las comparecencias iniciales.
The court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar.
Las órdenes del tribunal para la toma de huellas digitales y muestras de ADN que se hicieron el día 1 de este mes se aplican a estas causas también.
Persons appearing before this court have the right to remain silent and are reminded that anything they say could be used against them. Most of the persons appearing today are qualified for a court-appointed attorney. If you are not appointed an attorney, or even if you are, you may retain an attorney at your own expense.
Se les recuerda que todas las personas que se presentan ante el tribunal el día de hoy tienen el derecho de guardar silencio. Cualquier cosa que digan se puede usar en su contra. La mayoría de ustedes califican para el nombramiento de un abogado de oficio. Y si no califican para eso, también siempre tienen el derecho de contratar a su propio abogado.
At the conclusion of your hearing, you will be provided with paperwork detailing the orders in this matter.
Al final de su audiencia se les van a dar papeles que explican y tienen un bosquejo de la información que se haya dicho.
I will be calling each of you to the lectern one at a time.
Les voy a llamar a ustedes uno por uno al podio.
And we are going to start this morning with Ephine Urea. If Mr. Urea could come forward, and then next we're going to have Antonio Noyla Pina.
Primero pase por favor el señor Ephine Urea Valenzuela, después Antonio Noyola Pina o Piña.
Thank you. Can you please state your name, sir?
Señor, gracias. ¿Puede decir su nombre, por favor?
Ephine Urea, Valenzuela.
Ephine
And-
Urea Valenzuela.
What is your date of birth?
¿Y cuál es su
15
fecha de nacimiento?
15 de abril del 89.
April 15th, 89.
Thank you.
Gracias.
And Mr. Urea, you are here today based upon two charges. One, a first count of aggravated assault, temporary disfigurement, a class 4 felony, and assault with intent to or recklessly injure, a class 1 misdemeanor.
Señor, está aquí basado hoy en dos acusaciones. La primera es agresión con agravantes, desfiguro provisional o temporal, delito mayor de categoría 4. La segunda acusación es agresión intencional o temeraria con la intención de herir a otra persona, delito menor de categoría 1.
I have found probable cause and appointed you a public defender.
He determinado que hay motivo fundado para las acusaciones y he nombrado a un defensor público para representarlo.
You have the following upcoming hearing dates in this case.
Tiene las próximas audiencias programadas para esta causa.
A status conference on March 26th of 25 at 8:30 downtown.
Una consulta de actualización el 26 de marzo a las 8:30 de la mañana aquí en el centro de Phoenix.
And a preliminary hearing on March 28th, 25 at 8:30, also downtown.
Y una audiencia preliminar el 28 de marzo del 2025 a las 8:30 también acá en el centro de la ciudad.
Mr. Urea, I have set your bond amount at $100,000 as a secured appearance bond. Should you post that bond, you would be subject to pretrial supervision to include electronic monitoring.
Señor Urrea, he fijado la fianza para usted en el monto de $100,000. Es de caución real, o sea, asegurada. Si usted deposita la fianza y sale en libertad, va a estar bajo la supervisión de la Agencia de Control de Procesados, que va a incluir también monitoreo electrónico.
Mr. Urea, you are not to return to the scene of the alleged crime or have any contact with the alleged victim in the event you are able to post that bond.
Y
Do you
señor,
understand?
señor Urrea, está prohibido que tenga contacto en absoluto con la presunta víctima, ni tampoco puede regresar al sitio del supuesto delito. ¿Entiende usted eso?
Sí.
Yes.
Thank you.
Okay. There are some other conditions that apply should you get released as well, and the officer will have those for you in your paperwork.
Hay otras condiciones que se le van a aplicar si sale en libertad también. Van a estar en los papeles que ahora el agente carcelero le va a entregar.
Do you have any questions for me?
¿Tiene alguna pregunta para la juez?
Nomás quería saber pues si pues voy a seguir trabajando porque tengo mi trabajo.
I just
Y
wanted to
pues
know
ahí depende.
if I'm going to continue to be able to work because I have a job.
Sir, you are here unless until your hearing dates, unless you post the bond.
Señor, usted va a permanecer aquí hasta esas audiencias que le comenté, a menos que usted deposite la fianza.
¿Cuánto sería la fianza?
And how much is the bond?
$100,000 secured.
$100,000 asegurado.
Okay.
Okay.
Thank you.
Thank you, sir.
Gracias, señor.
Mr. Pena, if you could come to the lectern and Shelby Morgan, if you could take a seat by the door.
Señor Noyola Piña, si puede pasar al podio, por favor.
If you go ahead, Mr. Pena.
Pase, señor Piña.
And please state your name.
Diga su nombre, por favor.
Antonio Noyola Piña.
And Mr.
Antonio
Pena, what,
Noyola Piña.
and Mr. Pena, what is your date of birth?
Señor Piña, ¿cuál es su fecha de nacimiento?
El 10 de abril del 2004.
April 10th, 2004.
All right. And Mr. Pena, you are here today because you have been charged with possessing a weapon when you are a prohibited possessor.
Señor Piña está aquí hoy porque se le ha acusado de posesión de un arma de fuego por parte de una persona que tiene prohibido portar armas de fuego, delito mayor de categoría 4.
Hold on just a second.
Un momentito, por favor.
And you are also here on a charge of possession of drug paraphernalia. I have found probable cause as to the possession of weapon by a prohibited person. But,
Entonces, go ahead, Your Honor.
no, go ahead, interpreter.
Okay. He determinado que hay motivo fundado para la primera acusación, posesión de arma de fuego. La segunda acusación, posesión o uso de artefacto para consumo de drogas.
I have found no probable cause as to the possession of drug paraphernalia.
Y para la segunda acusación, los artefactos para consumo de drogas, no he determinado que hay motivo fundado para esa acusación.
I am appointing you an attorney, the Maricopa County Public Defender.
Estoy nombrando a un abogado para representarlo, la Defensoría Pública del Condado de Maricopa.
And you have two upcoming hearing dates. The first one is a status conference on April 3rd, 2025, downtown.
Y usted tiene dos audiencias en los próximos días. La primera es una consulta de actualización el día 3 de abril aquí en el centro de la ciudad.
And the second one is a preliminary hearing on April 7th, 2025, also downtown.
Y la segunda es una audiencia preliminar el 7 de abril, también acá en el centro de la ciudad.
And Mr. Pena, I am inclined to release you on your own recognizance as long as you promise to attend those hearing dates.
Y señor Piña, mi inclinación es dejarlo salir hoy bajo su palabra con la promesa de parte de usted de que va a asistir a esas audiencias.
Sí.
Yes.
Okay. And also, so long as you promise to abide by the other conditions of your release, which include not to possess any weapons.
Y también con la promesa de usted que va a cumplir con las demás condiciones de puesta en libertad que incluyen no poseer ningún arma.
Sí.
Yes.
Okay. In that case, do we need to reprint? Could we please reprint this paperwork? We will have, the officer will have paperwork for you, and thank you.
Entonces, el agente va a tener papeles para usted. Gracias.
And Mr. Pena, I apologize.
Le pido disculpas, señor Piña.
I forgot to ask if you had any questions for me.
Se me pasó preguntarle si tiene alguna pregunta.
Entonces voy a salir con fianza o como.
So am I going to get out on bail, or how does that work?
So I am releasing you today without bail,
Entonces lo estoy dejando salir hoy sin fianza.
but you need to be patient.
Pero necesita tener paciencia.
There is a process,
Hay todo un proceso.
and the detention officers will be able to walk you through that.
Y los agentes de detención le van a poder ayudar a entender eso.
Está bien.
That's fine.
Thank you.
Gracias.
Mr. Interpreter, can you ask if anybody else in the gallery needs the assistance of a Spanish language interpreter?
Sure. Buenas tardes, damas y caballeros. Si hay alguien más que necesite intérprete en español, levante la mano, por favor.
Nobody? No hand, man.
All right, thank you, Mr. Interpreter. That's all for right now.
You're very welcome. Have a great afternoon.
Thank you. All right, Shelby Morgan, and then if Garrett Alfred could have a seat by the door. Give me just a second, Ms. Morgan. All right, Ms. Morgan, you are here today because you have 2 out-of-county warrants.
Yes.
All right, so let's talk about the first one in your case ending 871. In this case, so in the 871 case, this was a warrant based on a charge of narcotic drug possession. I am appointing you, an attorney will be appointed for you. Yes.
I do already have a public defender. I'm actively working on this case out of Yavapai County. Her name is Ruth. I was supposed to be in court in Camp Verde today with her, and I was arrested last night. I've been actively working with her. The only reason why I missed court is because I went into preterm labor with my son.
Okay. So I'm going to go ahead, and for purposes of today's hearing, going to go ahead and appoint you an attorney. Check that box. Please continue to go ahead and work with your attorney. I'm also placing a secured appearance bond of $10,000 in this case. And then you have a hearing on, a hearing has been set on March 24th, 2025 in Yavapai County Superior Court in this case. All right, and then in the second case, which ends in 0984, this is a failure to appear. This is, I'm also appointing you an attorney in this case. Your hearing has been set on March 25th, 2025, also in the Yavapai County Superior Court. Secured appearance bond of $50 is being set in this case.
What does that mean?
It means that it is a secured appearance bond. And it's $50 so that you receive credit for the time that you are in custody. assuming that you still have to pay it to, if you want to, or post that bond in the event that you want to be released. If you are released, there are conditions that will apply to your release that will be in the paperwork that the officer provides to you.
I do have a question. So am I not going home today? I am exclusively breastfeeding my 5-month-old son, and I'm getting mastitis. I'm having a really hard time, and I don't know what to do.
So you do have to post the bonds to get released today. And that's just the nature of how it is. If you are having medical issues, there is medical staff in the jail, and you should bring that to their attention.
Okay. What would I've never been to jail before, so I don't know. Obviously, I don't have $10,000, but I was told that there's a percentage that can be paid.
So it is the $10,000 bond is a secured appearance bond, so you can work with a bonding company. I think that jail staff has the contact for the bonding company.
Okay, so I'm in custody for how long?
Well, I mean, unless you post the bond until your hearing dates, even if you do post the bonds and get released, you still need to go to those hearing dates. Okay? All right. Thank you. All right. All right, Garrett Alfred, and then if Clay Gibbs can have a seat by the door. Good afternoon, Mr. Alfred. Can you please identify yourself for the record?
Yes, my name is Garrett Alfred, birthday is 11/6/90.
All right. And Mr. Alfred, you have 3 items or 3 cases here today. I'm going to start with your new one. Which is the new charges are organized retail theft.
Yeah, I don't understand that, but...
Okay. And that occurred on March 19th of 2025. I did find probable cause. I am appointing you an attorney. And hearing dates have been set for... Assuming that you are still in custody, March 26th and March 28th, 2025, both of those are downtown. Do you understand that?
Yes, ma'am.
Okay. I am, in this case, inclined to release you on a secured appearance bond of $50. We're going to talk about bonds in the other cases as well. But just keep that in mind. All right, so let's look at the other case. Let's talk about the criminal case ending in 0423. This is, there was a warrant issued in this case.
Is that like the speeding ticket?
No.
What kind of ticket is it?
Hold on. There's an out-of-county warrant.
Yeah, LaPlace County.
For, hold on.
Excuse me.
Or failure to pay.
Oh, yeah, okay, so that's had a failure to pay, and then I have a contempt of court. I believe it's because I didn't go to court, or I didn't obey a court order, something like that. And so it's just because I'm not here in Maricopa County, and I'm from Parker, LaPlace County, right? And so it's kind of hard to stay in contact with them, and I'm not gonna lie, I kind of let it go because I'm not a county, and so I haven't really been taking it, or paying enough fines because I'm not a county.
Okay. Well, so in today's matter, I am setting. You have an arraignment hearing in Parker Justice Court on This particular matter on March 24th, 2025 at 8:30 a.m. I am setting a secured appearance bond of $1,716, which you would need to pay to be released today or in the next few days. So that's that one. Then the next one is hold on, also an out-of-county warrant.
Can I ask you a quick question, ma'am?
Yes, sir.
So on the new case today, is there any way I could get the OR, right? So that way I could go get those cases taken care of, right? So that way I could go to La Paz County, get those taken care of, because without the OR here, I'm going to be sitting here, and then I won't be able to get those taken care of. So I just asked that, Your Honor, so that way I could get that out of the way, and then I could just focus on the case that I have now.
And I understand that, but because of where we are in the proceedings and because those out-of-county warrants have been issued, I'm limited in what I can do.
Right.
In the second out-of-county warrant case, that is also for $1,751, and that I'm setting as a secured appearance bond. Assuming you are able to pay those 3 bonds, you would be eligible for release. The officer will have the paperwork for those 3 bonds.
So I just want to make it, I'll get it straight. So today, if I pay the $50 to this one, then the La Paz County is going to come get me, I believe.
If you are still in custody on your hearing dates, yes, you will be transported to
La Paz County?
To the county.
Okay.
Where the warrant's initiated.
Okay. And again, ma'am, there's no way you could OR me on this the new case, the $50 bond, so that way I could just go get those cases, because I believe that without the OR, they won't be able to come get me so I can face those matters, right? Because I'll be in custody here.
You're being held on the La Paz matters. You're being held here on the La Paz matters as well. So even if I release you on your own recognizance in the Maricopa matter,
yes, ma'am,
you'd still be here. By putting that $50 placeholder, it allows you to get credit for the time you're serving here in custody.
Can I just ask that? Ma'am, I really appreciate it. I'm thinking, well, honestly, because I know that I'm not going to be able to post a $50 retainer, and so I'm going to end up spending 3 months here, and then after the adjudication of this matter, I'm going to have to go and face La Paz, right? And so I'd ask that we do the OR, so that way I could face La Paz now, and then I could focus on this matter that we have at hand, because that's the problem. I know I'm not going to be able to post the $50, so I'm going to spend 3 months in here trying to fight this case, and then at the end of this case, I'm going to have to go face those cases. And then it's already a lot of stress on me as it is, And so I just ask that you could please just, give me this one chance. I'm going to be honest with you, Honor. I've never gotten an OR on any of any case, and so I just ask that you please give me this one chance to show or prove myself, really.
Okay, sir, even if I were to release you OR on the Maricopa County matter, you're not going to get released. We're still holding you on.
I understand
on the other matters.
I understand that completely.
It's at this point, because of where you're at, it's all one, and you're still going to be held.
I understand that, but so when the 24th comes and I got to go to La Paz, I'll be held on this matter still. Is what I'm saying, and then I'll have to come back and face this case again. Right, so La Paz County will OR me, or I'll face those, and then I'll still have to come back here and face this case again. And then I just ask that you give me the chance to face it from the streets this time.
You are going to have to come back to Maricopa County, because in the Maricopa County case, you do have a hearing.
Yeah, I understand that. I just asked you to OR me so that way I could come back on the streets and fight it from the streets instead of having to spend like the next 3 months and make a wrong decision that I've always made in my life because I always had to fight a case from jail, or, you know, from jail. And so I take the first plea they come at me with, and it's not always the best. You know, I'm honestly, to be honest with you, ma'am, I've gone to prison because it's the easier way out. And when I was innocent in the case, it's just I knew that it'd be faster to face the case in prison, plead guilty to it, and spend 8 months in prison and spend a year in county. And so I just asked you to give me this one chance because I don't believe that I'm guilty of organized retail theft.
And I did find probable cause as to the incident that occurred at the Lowe's here in Maricopa County.
Yes,
and I have considered your situation as well as the allegations in the Maricopa County shoplifting matter.
Yes, ma'am.
And my decision stands.
Thank you, Your Honor.
You can get your paperwork from the officer.
Thank you, ma'am.
All right, Clay Gibbs, please, and then if Angelica Garcia could take a seat by the door.
Good afternoon, Your Honor.
Good afternoon. Can you please state your name for the record?
Clay Daniel Gibbs, 5/3/1988. Do you mind if I say one thing on this case? I was actually already arrested on it, and I went to all my court proceedings, and it got dismissed, and I have no idea why I was picked up on the same grand jury indictment that I took. Yeah, it was dismissed just recently. I have my paperwork. I was just in court for it.
Okay, well, you're here today on a grand jury warrant. So for trafficking in stolen property and theft of property. So you do have I am appointing you an attorney today. If you have questions, you can talk to that attorney.
Okay. That's what I was grand jury indicted for, the same thing.
Okay, well, you can talk to your attorney, but for today, I'm going to go ahead there and let you know that there is a hearing set for March 27th of 2025 downtown, and I am
please be OR and fight this out of court, man.
I'm going to go ahead and assess you a secured appearance bond of $1,000. If you are able to get that appearance bond secured, then you would be released at that time, subject to your compliance with release conditions, including not returning to the scene of the crime or of the alleged crime or having any contact with the alleged victims.
I don't even know what the crime is.
Okay, so you have been charged with trafficking in stolen property and theft.
What's a stolen property?
Okay, so this is something that you can take up if you have questions with your attorney. Your attorney will be able to help you with that.
I have a card I can use to pay the bond today. Can I be released?
So officers will be able to provide you with information about contacting a bonding company. And the officer has your paperwork there.
All right.
All right. Thank you, Mr.
I don't understand how I got arrested for something I already went to trial for. You got dismissed. I have my paperwork. It doesn't make any sense.
Angelica Maria Garcia, and then Brian Reyes. If Mr. Reyes could have a seat by the door. Good afternoon. Can you please state your name for the record?
Angelica Maria Armenta Garcia, 121375.
And Ms. Garcia, you are here today on a charge of a probation violation. I am appointing you an attorney, and you have 2 upcoming hearings that have been set, both downtown. One on both on March 27th at 8:30, okay? All right, I am setting you a secured appearance bond of $1,000. And in the event you are able to post that bond, you would be released subject to the terms in the release order. Do you understand?
Mm-hmm.
Do you have any questions?
No.
All right. The officer will have your paperwork for you. Mr. Reyes, if you could go ahead and come up to the lectern. And then Roelio Smith is next. If Mr. Smith could please take a seat by the door. All right, Mr. Reyes, if you could please state your name for the record.
Brian Reyes.
And Mr. Reyes, what is your date of birth?
4/14/93.
Okay. And you are here today on charges of an aggravated DUI, failure to obey police officers, aggravated DUI. I'm sorry, your first aggravation was your third DUI. Your second aggravated DUI is driving on a suspended or revoked license. Also a charge of unlawful flight from law enforcement, reckless driving, and exceeding the posted speed. I did find probable cause to support those charges and have appointed you an attorney. You have two upcoming hearings, one on March 26, 2025 at 8:30, and a second one on March 28, 2025, also at 8:30 at the Downtown Superior Court. Okay? I have set a secured appearance bond of $1,000. Should you be able to post that bond, your release would be subject to certain release conditions, including that you not consume alcohol and that you not drive a motor vehicle without a valid driver's license, which it appears you do not have, so don't drive a car. Okay.
Your Honor, if I may?
Yeah, hold on just a second. Just a second. Okay. Mr. Reyes, in the event you post your bond, I am going to require that you, because this is your third DUI, go ahead and get drug and alcohol testing as a condition for release. And I'm sorry, you had a question.
So I'm being released today?
You have to post bond. In the event that you are able to post your $1,000 secured appearance bond, you will be eligible for release, but you will need to be patient. One, you need to post the bond. Two, it's going to take a little while for the officers to be able and staff to be able to process you. Okay?
I have a problem though because they have my phone confiscated and I have money on my Apple Pay.
Okay. So you're going to have to talk to jail staff about contacting a bonding company. I don't think that they can give you access to your personal effects,
I understand.
but they will be able to assist you in contacting a bonding company. Okay?
Thank you.
All right, thanks. All right, Mr. Smith, and then if Carlos Bali could please have a seat by the door. Mr. Smith, can you please state your name for the record?
Rogelio Carrasco Smith.
All right, and Mr. Smith, what is your date of birth?
1/24/83.
Okay. And you're here today on a bench warrant for failure to appear. You have an upcoming hearing set in Superior Court. You already have an attorney that's been appointed to you because of failure to appear matter. You have an upcoming hearing in Superior Court on March 26, 2025. I am setting a cash-only appearance bond in the amount of $1,000. Okay? All right. Do you have any questions?
No.
Okay. The officer will have your paperwork for you.
Okay, thank you.
All right, Mr. Bali. And then if Diane Talamonte could have a seat by the door, please. All right, please state your name for the record.
Carlos Bali.
Okay, and I'm actually I'm kind of glad that I pronounced your name right. And Mr. Bali, what is your date of birth?
11/28/1989.
Thank you. And Mr. Bali, you're here today on an arrest warrant out of the Superior Court. I am appointing you an attorney. And 2 hearings are being set, both downtown, one for March 26, 2025 at 8:30, and then a second one on March 28th, also at 8:30, both downtown. I am setting a secured appearance bond in the amount of $2,000 in the event that you are able to post that bond. You will be subject to certain release conditions, including pretrial services, supervision, including drug and alcohol testing, as well as certain other release conditions, which will be in your paperwork. Mr. Bali, do you have any questions?
Yes, Your Honor. I have trial on Monday for a DUI case that I currently gonna, hopefully get overturned if I lose trial with the appeal. But what I'm trying to say is that case right there caused this DUI that I'm facing for the felony warrant. And also, I was never. I know there's statute of limitations pertaining to being summoned to court with subpoena. I was never subpoenaed properly. Therefore, I wasn't aware of the court date that I had for this felony warrant. So, not being processed and served right, I was totally unaware, and that's why I had the non-appearance.
So those are all things that you can bring up and talk to with your attorney. Okay.
Okay.
All right. Thank you, Mr. Bali.
Okay.
Appreciate it. All right, Ms. Talamonte, and then if Shakai Augusta could have a seat by the door, please. All right, Ms. Talamonte, please state your name for the record.
Diane Arlette Talamonte.
I'm sorry, what is your first name?
Diane Arlette Talamonte.
Okay, and Ms. Talamonte, what is your date of birth?
12/2/91.
All right, and Ms. Talamonte, you are here today on 2 Superior Court warrants for probation violation. I am appointing you. Let's talk about your first case, which is the 3001. I am appointing you a public defender in this case and setting 2 hearings, both down at the Downtown Superior Court, both on March 27th, 2025 at 8:30. I'm setting a secured appearance bond in the amount of $500 on this first 3001 case. In the event that you are able to post that bond, your release would also be subject to certain conditions, which would be in the paperwork. In the second case, also a probation violation a probation violation matter, also out of the Superior Court. I'm also appointing you a public defender in that matter, and 2 hearings are set in the second matter, the 001 matter, both on March 27th, 2025, both also at the Downtown Superior Court. And I am setting a $500 secured appearance bond in this matter. So both your matters together, $1,000 secured appearance bond, okay?
Okay.
All right, in the event you are able to post bond in the second matter, your release would also be subject to certain conditions there. Do you have any questions for me?
No, ma'am.
All right, officer will have your paperwork. Thank you very much, ma'am. Ms. Augusta? And then if Brielle Hukansfield, and I'm sorry about that, could have a seat.
Hukansfield.
Oh, thank you.
Yeah.
All right. All right, Mr. Augusta.
Yes, ma'am.
And I apologize. If you could please state your name for the record.
Shakai Augusta. My birthday is June 3rd, 2004.
All right. And Mr. Augusta, you are here on 3 matters today, so let's go ahead and if we could talk about your first matter, which is possession of dangerous drugs and charges. The charges here are possession of dangerous drugs and drug paraphernalia. Did find probable cause for those charges. I am appointing you a public defender.
Thank you.
And 2 hearings have been set in your case. Both of them are downtown at the Downtown Superior Court. The first one is on March 26th, 2025, and the second one is on March 28th, 2025. I am, in this matter, setting a $50 secured appearance bond.
Thank you.
And we're going to talk about bonds in the other cases, so just keep that in mind, but $50 in this case. Secured appearance for this case. In the event that you are able to secure that bond, there would be additional release conditions, which would be in the paperwork. All right, let's talk about the second case, which is the 2001 case. This is a warrant for a probation violation, and also appointing you an attorney in this case, and 2 hearings have been set in this case as well, both of them at the Downtown Superior Court, both on March 27th, 2025 at 8:30. I am setting a secured appearance bond in the 2001 matter in the amount of $500. Finally, in your last matter here before us today, this is the 8001 case. This is also a warrant on a probation violation case. Also, I'm also appointing you an attorney in this case. And 2 hearings have been set on the 27th, on March 27th, 2025, downtown at the Superior Court. The secured appearance bond in this case is $500. So it is a total of $1,050 for all 3 cases, secured appearance bond. All right. Do you have any questions? Okay. So the officer will have your paperwork and show up to your court hearings.
I will.
Thank you, sir. All right, Brielle, now I need Mr. Augusta back. Hukansfield, and if Angelica Taylor could have a seat by the door. Good afternoon, ma'am. Could you please state your name for the record?
Brielle Hukansfield.
Hukansfield. Okay, it's a hard one. All right, and Ms. Hukansfield, what is your date of birth?
4/29/04.
All right, and you are here today, Ms. Hukansfield, on a bench warrant from the Superior Court for failure to appear. You already have an attorney that's been appointed for you, but there's a hearing set. I'm going to let you know about that for March 31st, 2025 at 8:30 at the Downtown Superior Court. I am setting a cash-only appearance bond of $500. So you post that $500 and you can be released, okay?
Okay.
As long as you promise to go to your court appearances, right?
Yeah.
Okay, and there will also be release conditions that you need to comply with, all right?
All right.
Okay, officers will have that paperwork for you. Do you have any questions for me?
No.
Okay, thank you, ma'am.
Thank you.
All right, Ms. Taylor, if you could please come to the lectern, and then Musen Ahmed, if you could take a seat by the door, please, sir.
Hi, Your Honor.
Hi. Ms. Taylor, please state your name for the record.
Angelica Taylor.
All right, and Ms. Taylor, what is your date of birth?
July 6, 1972.
All right, and Ms. Taylor, you are here today on a Justice Court case for driving with a suspended license.
Out of what city is that, Your Honor?
Hold on, and I will let you know.
Okay.
Oh, out of the West McDowell Justice Court.
Which one?
West McDowell.
Is that really like Kyrene or something? I don't know, because I had set up a payment plan. It was pertaining to like a no turn. I turned right on red, and no insurance and suspended license a few years ago. And it showed up a year ago as I started my payment plan, and the payments have gotten away from me. So I think.
So you're going to be able to take that up with them at the arraignment hearing, which is set in the West McDowell Justice Court on March 25th, 2025 at 8:30 a.m., okay? Now, I'm inclined today to release you on your own recognizance as long as you promise to go to that March 25th, 2025 hearing.
May I share with you?
Sure.
Okay, so, yes, I will definitely honor that. I was coming home from work, and I normally get a ride to work.
All I need to know is that you're going to honor
I'm going to do it.
Okay, because we don't want to do this again, right?
Okay, no, I want to do it.
Okay, so do it.
Thank you.
And then there will be some additional conditions you need to comply with, which will be in your paperwork, which the officer can give you.
No problem. Thank you very much.
Thank you, ma'am. All right, Mr. Ahmed, and then if Adriana Nez could have a seat by the door, please.
Hello, Your Honor.
Hello, Mr. Ahmed. If you could please state your name for the record.
Musen Ahmed.
Okay. And Mr. Ahmed, what is your date of birth?
25th of March, 2000.
Wait, say it slower.
25th of March, 2000.
Ah, okay. All right, Mr. Ahmed, you are here today because you have been charged with reckless driving and exceeding posted speed in the University Lakes in the University Lakes Justice Court. I am not appointing you an attorney in this matter, but a hearing has been set for March 25th at 8:30 in the University Lakes Justice Court. Okay, that information will be on the paperwork too, but please go.
Okay.
I am inclined to release you on your own recognizance today as long as you promise to go to that hearing.
I promise.
Okay, as with the previous lady, you don't want to do this again, right?
Yes.
Okay. All right, so do you have any additional questions for me?
Yes, ma'am. So I have a hearing on the 25th, but I'm free to go today?
Well, you just can't walk out the door because that's not the way it works, right? So you're going to need to talk to jail staff, and they will help you through the process. Oh, I'm sorry, my bad. I'm sorry. It's your arraignment hearing is actually on April 8th, 2025. You promised you'd go, so that's the one you need to go with. That is the information that will be on the paperwork. And I'm sorry, now that I've corrected myself, do you have any other questions?
Yes, Your Honor. So I'm free to go today, right? After I finish processing?
After you finish processing, yes.
Thank you so much.
Okay. Thank you, sir.
Thank you.
All right. Adriana Nez and then Mark Baca, if Mr. Baca could please take a seat by the door. All right, Ms. Nez, could you please state your name for the record?
Adriana Nez.
And Ms. Nez, can you please state your date of birth?
06/1998.
Thank you. And Ms. Nez, you are here today on a Superior Court arrest warrant. based upon a previous charge of aggravated DUI license while your license was suspended or revoked. I am appointing you an attorney and setting 2 hearings in this matter. The first one for April 3rd, 2005 at 8:30 in the downtown Superior Court, and the second one on April 7th, 2005, also at the downtown Superior Court. Now, Ms. Nez, I am inclined to release you on your own recognizance today, so long as you promise to appear for those 2 hearing dates.
Yes, I will.
Okay. So, perfect. So, that being said, there's a few more release conditions. Please read those. Those are in the paperwork. Do you have any questions for me?
No.
Okay, officer, we'll have those for you. Thank you very much. Mr. Baca, and then Jamaica Westbrook. Mr. Westbrook, if you could have a seat by the door, please.
Good afternoon.
Good afternoon, Mr. Baca. Mr. Baca, could you please state your name for the record?
Mark Anthony Baca. My birthday is 12/11/88.
All right.
How are you doing today?
I'm doing okay. So you are here today, sir, on a Superior Court arrest warrant. I am appointing you an attorney and setting two hearings for you. The first one is on April 3rd, 2005 at the Downtown Superior Court. The second one is on April 7th, 2005. I've gone back 20 years. The first one is on April 3rd, 2025 at the Downtown Superior Court. The second one is on April 7th, 2025 at 8:30, both at 8:30, both downtown at the Superior Court. Mr. Baca, I am releasing you today on supervised release, subject to pretrial supervision, okay?
Okay.
All right, so you need to check in with them, but officers will have that information for you on your way out. Do you have any questions for me?
Thank you very much.
All right, thank you,
Appreciate
sir.
it, and I'll be there.
All right.
Thank you.
Mr. Westbrook, please. Mr. Westbrook, if you could please state your name for the record.
Jamaica Westbrook, 10/17/1981.
Thank you, Mr. Westbrook. Mr. Westbrook, you are here on two new charges. The first is dangerous drug or possession of a dangerous drug, and the second one is possession of drug paraphernalia. Both of those offenses committed on March 19th of 2025. And Mr. Westbrook, after review, I did not find probable cause for either one of those charges. However, that does not mean that those charges those charges may not be filed at a later time by the county attorney, but for today, the county attorney could file those at a later time. And I'm going to go ahead and set two hearings. The first is for April 3rd, 2025, and the second is for April 7th, 2025. Both of those are downtown. So go to those hearings, okay?
So is my charge dismissed?
I'm not finding probable cause. I can't dismiss charges. I'm just not finding probable cause to hold you here today, sir. All right,
Okay.
Those charges can still be filed by the county attorney. All right, this is just a very preliminary determination. Okay, go to those two hearings.
Okay.
Officer will have paperwork. Do you have questions?
No.
All right. Thank you, sir. Have a good day.
Tomorrow.
All right, Joshua Pearson, and then if David Ledesma could have a seat by the door, please. Ms. Pearson, please state your name for the record.
Joshua Michael Pearson,
All right, what's your date of birth, sir?
11/30/75.
All right, and Mr. Pearson, you're here today on an out-of-county warrant for a probation violation. An attorney will be appointed at your next hearing, which is set for March 24th, 2025 in Pinal County Superior Court. You are not available today as a matter of right because of the probation violation. All right, but you can talk to the judge at the March 24th. I'm not going to set a bond or release conditions today, but you can talk to the judge at the arraignment hearing on March 24th of 25 about what, if any, release conditions that judge may think is appropriate.
The thing that happened is I have probation out of Pinal County, correct? And they were allowing me to do it in Scottsdale, and so that's where I live, doing my probation in Scottsdale. I was in constant communication with my probation officer, who was my contact. I was actually in her office when I was arrested by, because of the Pinal County warrant. I don't know how, I had no idea there was a warrant. I had no communication from them. They didn't reach out. They didn't send me anything. They said nothing. The probation officer that's my contact for that probation. We didn't know anything. And so, I want to go to my court appointment, all that, but this is just, there was no summons. There was no communication with me at all.
Okay. So you can take all of that up with the judge on March, let me get the date right.
So I'm going to be here for the next 4 days?
Until March 24th, 2025 at 8:30. So
why am I not bailable by right? I heard other people bailable on their probation violation.
So this is an out-of-county warrant. This is the Pinal County's instruction that you be held non-bondable, and so I'm affirming that. So the officer will have your paperwork, sir.
My gosh. Do you understand the probation thing that it was transferred to Scottsdale?
And that is the question for the Pinal County. That's the issue for the Pinal County judge on March 24th of 2025. I've done what I can.
Oh my gosh.
All right, David Ledesma, and then if David Ledesma, please. All right, Mr. Ledesma, can you please state your name for the record?
David Ledesma.
And what's your date of birth, sir?
August 1st, 1996.
And you're here on a municipal court warrant out of the El Mirage Municipal Court. And the El Mirage Municipal Court has set your hearing, or your next hearing, for April 8th of 2025 at 8 a.m.
Okay.
Okay? I'm inclined today to release you on your own recognizance as long as you promise to appear at that hearing.
Yes, ma'am.
Okay, now you've had some issues appearing at other things before.
Yeah, I've just been having trouble with being homeless now.
Okay.
But other than that, I'm working on it. I'm trying my hardest, trying to keep out of trouble, but it just keeps dragging me in little by little, but trying my best.
Okay, so are you going to go to that April 8th, 2025 hearing in El Mirage Municipal Court?
Yes, ma'am.
Okay, so I'm going to release you today on your own recognizance, subject to certain release conditions, which will be in your paperwork, which the judge will have, which the officer will have for you. Do you have any questions for me?
No, ma'am.
All right. With that, sir, you can get your paperwork.
Thank you.
All right. Yeah, so that's your house call. Officer, have we heard from everyone?
We have Ms. Bard, and then we have Ms. Roy as well. So Ms. Bard is a judge.
Okay, so I'm going to make a record on the house calls, and then we'll move on to Ms. Barr after I put the house calls on the record, if that's okay with you. Okay. All right. Ms. Barr is the only person left in the gallery, is that right?
We also have Mr. Monroe, Mr. Roy, right over here.
So I'm going to do the last two. Oh, I'm sorry. So just make the record. Okay. All right. So, and do you know, officer, why Mr. Gonzalez, Mr. Gomez, and Mr. Sanders are not present?
Let's see. Mr. Sanders. One moment. Mr. Sanders is combative.
Okay. Mr. Gomez?
Gomez. UTF, unable to function.
And Mr. Gonzalez?
And Gonzalez. UTF as well.
Okay.
Combative.
All right. So these are the two matters of Emilio Gonzalez, date of birth 11/7/1998. Mr. Gonzalez is not present in the hearing room because officer informs the court that he is unable to function. Mr. Gonzalez's first matter, the 6001. Is a Superior Court, Mr. Gonzalez is on a Superior Court probation violation warrant. I am appointing an attorney. My intention, and two hearings have been set. The first one is on March 27th, 2025, and the second one is on also on March 27th, 2025. Both hearings are at 8:30 in the downtown Superior Court. My intention is to set a secured appearance bond in the amount of $1,000 in this case after speaking with Mr. Gonzalez. If that changes, I will update the release order. In the second case, ending in 1001 for Mr. Gonzalez. This is also a Superior Court probation violation warrant. And I am appointing an attorney for Mr. Gonzalez. And there are two hearings set in this case for March 27th, 2025 at 8:30, both hearings at the downtown Superior Court. In this case, also my intention is to set a $1,000 secured appearance bond in this second matter. If after speaking to Mr. Gonzalez that changes, I will update the order. With regard to Isaiah Gomez, Mr. Gomez, I am informed by the detention officer is also unable to function. Mr. Gomez, whose date of birth is 11/2/2003, is here today on three cases. The first are charges of theft of a means of transportation, burglary, a Class 3 felony, burglary in the second degree, a Class 3 felony, possession of drug paraphernalia, a Class 6 felony, and resisting arrest, also a Class 6 felony. I am finding probable cause as to those charges. In addition, I am appointing Mr. Gomez, an attorney, and there are two hearings that have been set for Mr. Gomez, one on March 26, 2025 at 8:30, and the second one on March 28, 2025, also at 8:30, both in the downtown Superior Court. My intention is to set a secured appearance bond in the amount of $5,000 for Mr. Gomez in this case ending 2001. The second case involving Mr. Gomez is case 001, and this is a probation violation. I am appointing an attorney to Mr. Gomez. 2 hearings have been set, both for March 27, 2025 at 8:30, both in the downtown Superior Court. I am setting a $1,000, my intention is to set a $1,000 secured appearance bond in this case. Finally, Mr. Gomez is here on a third case, which is 1001. This is a Superior Court probation violation warrant case. I am appointing an attorney, and 2 hearings have been set, both on March 27, 2025, both at 8:30 in the downtown Maricopa County Superior Court. My intention is also to set a $1,000 secured appearance bond in this case. After talking to Mr. Gomez, if any of these release bond conditions change, I will update the order. Finally, Mr. Arnez Sanders I'm informed by detention officers that Mr. Sanders is not in the gallery because he is combative. His date of birth is September 9th, 1998. Mr. Sanders has been charged with possession of dangerous drugs and criminal trespass. The dangerous drug possession is a Class 4 felony, and the criminal trespass is a Class 6 felony. I have found probable cause as to both. I am appointing an attorney for Mr. Sanders. And 2 hearings have been set in this case. The first hearing is on March 26, 2025, and the second at 8:30, and the second one is on March 28, 2025, also at 8:30, both in the downtown Superior Court. My intention is to place a secured appearance bond of $1,000 in this case. Mr. Sanders' second case, which is 1001, this is a probation violation warrant, or a case here on a warrant for a probation violation. I'm appointing Mr. Sanders an attorney in this case as well, and 2 hearings have been set. The first is both on March 27, 2025, both at 8:30, both in the downtown Maricopa County Superior Court. My intention is also to set a $1,000 secured appearance bond in this matter. In the event, after speaking to Mr. Sanders, this changes, then I will update the order.
All right, and then I'm going to see Ms. Barr, please. And then after Ms. Barr, I'll need to clear the courtroom for a couple of minutes. All right, good afternoon, Ms. Barr. Can you please tell me your full name and your date of birth?
Lanya Barr, 5/18/93.
All right, thanks, ma'am. So I have you here on 2 matters. You're here on a new case. You're arrested on, it looks like, 1 allegation of, what's your new case? You're arrested on 1 allegation of resisting arrest, which is a Class 6 felony, 2 allegations of aggravated assault, which are Class 3 felonies, and then 7 allegations of endangerment, which are Class 6 felonies. I did find probable cause to support those allegations, so I'm appointing a lawyer to assist you. You're going to have court on March 26th and March 28th at 8:30 in the morning in the downtown Superior Court. In that matter, you have a $20,000 secured appearance bond. I'm also ordering that should you post that bond and be released, that an electronic ankle monitoring device be installed prior to your release from custody, and that you comply with pretrial services restrictions as to when you can leave your home and where you can go. I'm also ordering that you comply with all of the written instructions in your paperwork. It's going to include that you're not to have contact with any alleged victim or witness, You're not possessing any weapons. There's other orders you'd have to comply with as well. You're also here, ma'am, on a warrant from another state. It looks like you're here on a warrant out of Lake County in Indiana for an alleged larceny or theft matter. In that case, you are entitled to what's called an extradition hearing before they can take you back to Indiana. Did you get a chance to read that laminated piece of paper?
Yeah, I really didn't understand.
Yeah, it's okay. I'm going to walk you through kind of your options, and then let me know if you have any questions. So you have the right to an extradition hearing. That's the default, that it's your right to the hearing. So if we go with that option, I'm going to set your next court date here in downtown Phoenix on March 31st at 1:30 in the afternoon. You'd have a $20,000 bond in that matter. That process, the extradition process, is essentially where you are demanding that a governor's warrant be signed by the governors of both Arizona and Indiana before they could be able to take you back to Indiana. That process of the state trying to get a governor's warrant signed can take anywhere from 60 to 90 days. So that's kind of option number one. Option number two is if you know you want to go back to Indiana, you don't want to contest going back, you can waive your rights to an extradition hearing. If you choose that option, you'd be held without bail in this Indiana matter, and Indiana would have 30 days to come and get you. But the only wrinkle for you is that 30 days wouldn't start until the conclusion of any local cases that you have. So since you were arrested on this new case would have to be concluded before that 30-day time period would start. I have no idea when this new case is going to conclude. Maybe the county attorney doesn't file charges and it gets concluded right away. Maybe you take it all the way to trial and it could take months. I don't know. Unfortunately, you don't necessarily have a way to know right now either. But whatever the case may be, once your local charges are resolved, Indiana would have 30 days to come and get you. If they don't come and get you in those 30 days, you'd be released. Now, that doesn't mean the warrant goes away. The warrant could still be valid and active, but you'd be released from custody. So those are kind of your two options. If you're not sure what you want to do today, I can set your hearing on the 31st. And then if you want to do the waiver at that point, like you find out that your case went away, your new case went away, you could do the waiver then. I just offer the waiver at this juncture because some people know they want to do the waiver to try and start that 30 days as quickly as possible, and so they want to do the waiver right now. Okay. Do you know what you'd like to do?
I would like to figure that out. You said at the next court date I can?
Okay, yeah. So then I'm going to set your next court date on March 31st at 1:30 in the afternoon. I'm going to indicate that for the time being, you're not waiving your rights. You have a $10,000 bond in your Indiana case, and you have a $20,000 bond in your new case. So your total bond is $30,000 secured appearance.
So if I pay $30,000, I can get out on both?
Correct. Yep, but then you have to go to your court dates, okay?
Yeah.
All right, any other questions?
Yes, so I will have to pay both of them to get out.
Yeah, don't just pay one, because then you'll still be in custody.
So what if I pay the Indiana one? That one is $10,000, you said, right?
Right.
And that one, if I pay $10,000 on that one, and then I go to court on the 31st, and maybe those charges are get like dropped or something?
So I can't give you legal advice, but what I can tell you is this. Right now, you're being held on bond in both of those cases. So unless you find out, like let's say you find out that the new case you got arrested on, that goes away, then the only thing that would be holding you is the Indiana one, and you could try and post your bond there and make sure you get to your court dates here. But unless you'd either need to find out that one of the cases went away, like one of the holds dropped, otherwise you're going to have to post bond in both cases in order to be released. If you just post bond in one of your cases, you're not going to get released. The only thing that'll happen is you're not going to get credit for the time you're serving in custody. Your next court dates are coming up pretty soon because it's the 31st for the Indiana matter and it's the 26th in your new case. In your new case, you have a court-appointed lawyer. In the Indiana matter, technically, you're not entitled to court-appointed counsel. Sometimes there is someone from the public defender's office there that's helping people. But on the 26th, you'll have a lawyer. So ask your lawyer your questions about whether you should post your bond in one case or another, okay?
Okay, and another question. Those 7 people that you were talking about for the endangered, those are my kids. So I would never put my kids in danger.
I understand.
I have 8 kids, and I'm a single mom. So I want to know, like, will I still be able to be around my kids and stuff when I get out?
So not right now. For the time being, I'm ordering that you cannot have contact with them. That doesn't mean forever, but for the time being, because part of the issue is I don't have enough information to, make any determinations beyond that. I don't know if they have other legal guardians who might want to have a say. I don't know what DCS's position is. So my answer is not forever that you can't have contact with them, but the answer is for right now. If you got released, you can't have contact with them right now, okay?
Okay, so just say if I find out today, I can't have contact with my kids, so they have to go with their dads or their grandmas or something.
Exactly.
And then probably when this case is over or something, or if I go to some type of classes or something.
Right, and I have there's so many different possibilities of what could happen when this case resolves. I have no idea. So that's something that you'll have to talk with your lawyer about.
Okay.
All right. Any other questions, ma'am?
No.
All right. Go ahead and step to your left, ma'am, and they'll get you a copy of your paperwork.
Thanks.
Oh, great. Okay. Let me see if I can get on as well. All right. Thank you very much. If we can let defense counsel know we're finally ready for his matter. All right. Good afternoon, everyone. Counsel, I apologize for the long wait. Unfortunately, I had to be at the end of the calendar. Counsel for the state, can you hear me? I can't get our video to work, but you should be able to hear me.
Yes, Your Honor, I can. Tom Van Dorn for the state.
All right, wonderful. Then we're going to call number 27 on, or I'm sorry, number 27 on our calendar, Henry Monroy. We just had state counsel appear, counsel for defense.
Good afternoon, Your Honor. Mark Adair, Suzuki Law, on behalf of Henry Monroy. As you've probably seen, this is just a limited notice of appearance for purposes of this initial appearance only. Just out of an abundance of caution, I'd ask that you appoint him public counsel, and then obviously if we're retained on the full case, if it goes that far, then we'll do a substitution of counsel.
Thank you very much. And Mr. Monroy, can you please tell me your full name and your date of birth?
It is Henry Ulises Monroy, and my date of birth is 06/27/1993.
Thank you. All right. So we are here on a new case. Defense counsel, for your benefit, my staff let me know that the county attorney was attempting to rebook Mr. Monroy under the child enticement statute, which I believe is, counsel for the state, can you tell me which subsection that is? I wrote it down and then forgot to bring it into court.
Yes, Your Honor, I can look it up. I believe it's ARS 13-1430, but I can double check it real quick myself.
I think I have it here. Let me know when you've had a chance to look that up.
You bet.
May I inquire if he has actually been rebooked on that, or is that what their desire is?
That therein lies the issue. So just hold tight really quickly.
Yes, Your Honor, it is ARS 13-1430. So, Your Honor, go on the record. I can go ahead and explain to you what the state attempted to do if you'd like me to do that.
That would be wonderful, because I want defense counsel to obviously be able to hear.
You bet. So, Your Honor, in reviewing the Form 4 that was submitted by law enforcement and taking a look at the current statute that they booked him on, I reached out to law enforcement to do them what is called a scratch ad. If you read the last sentence of this Form 4, it appears that the detective's intent was to book this defendant for child enticement and not the luring statute that is currently showing up. So when the detective and the Phoenix Police Department went down to MCSO ITR to attempt to scratch the current charge and add ARS 13-1430, the child enticement statute, apparently the system right now does not have that statute in their system, so they're not even able to scratch this current charge and add that charge. I was told over the phone by MCSO personnel that they reached out to the courts. I'm sorry, I did not get a name with who they spoke with over there in court admin. And court admin suggested that since it is not currently available, that we just leave the current statute and proceed with the matter from there.
Okay, and I didn't want to have any communication regarding this. I had seen that notice of appearance was filed, so that's why I want to have this discussion in this context. Thank you for laying that out. So it's this court's opinion that I think that a system error should not prohibit the state from alleging the charges that they intended to allege. So in this case, my understanding is that the state and the arresting officers followed the procedures that were necessary, intended to have the defendant arrested for 13-14-30, which is child enticement, but because there is some sort of issue in the system was not able or willing to accept that. This has happened before in the past. When that has happened, what the court will ultimately do is, after we conclude our hearing, it would be my intention to print a release order, hand edit the alleged charge that we are doing the IA for to child enticement, which is, as Mr. Van Dorn just noted, the allegation that they were intending to arrest him on, and then I would have that hard copy of the release order uploaded to correctly reflect the allegation that the state was attempting to pursue today. So that's my intent. I want to hear from both parties first. Defense counsel, obviously, I know that you were here assuming that it was an ag-luring allegation, so if you need to take a moment, I'm more than happy to give you any time that you need. So that's the first matter that I want to address. Counsel for the state, do you have any position regarding the proposed way in which I would like to handle this?
No, Your Honor, the state has no objection to the way the court wants to handle the matter. The state does concede that they do believe that there is probable cause for ARS 13-14-30, the child enticement statute. But like previously stated, that due to a system error, law enforcement does not even have that as a selection in the booking system at the present time. Thank you.
Counsel for defense, do you want some extra time before we discuss? First, just before we get into probable cause, I'm not asking you to address that. But just in terms of my proposal that I allow the IA to proceed under this charge and then ultimately reflect that in the record moving forward.
Your Honor, I heard what your intention was, and I certainly respect that. I've been practicing for 33 years. It's never happened to me, and I've come to IA courts many, many times over 33 years. I would expect counsel for the state is making an avowal as an officer of the court. I respect that as well. Put in the position that I'm in now, coming to court, reviewing the Form 4 on the 3560 charge, which I would be arguing no probable cause, and that's probably what was recognized. I do object to not having that information now. That's what he was booked in. There's nothing in the system. Our rules of procedure are very clear as to what has to happen in certain time frames. And again, I respect what the court wants to do, but for the record, I'm going to object to that process being used in this particular case, as he is formally being held on the book charge of luring 3560. So just to answer your question in that regard, that's my response.
Thank you, counsel. All right, and I appreciate that. Over your objection, I am going to proceed on the IA for 13-14-30, which is the child enticement statute. Given, as you just mentioned, that you were initially anticipating proceeding under the egg luring statute, do you want a few moments?
I'm pretty good at doing it on the fly. Just give me just a minute here, Judge.
No problem. We'll stand in recess for just a moment. Mr. Van Dorn, if you would, please stand by.
Thank you, Your Honor.
I'm ready, Judge, when you are.
All right. All right, so we are here today on an initial appearance for one count of child enticement. I am going to appoint the Public Defender's Office out of an abundance of caution, as defense counsel requested. For first, just as it relates to probable cause, I did review the Form 4 in this matter. State, I know that you said you felt there was probable cause. I have some concerns even under the child enticement statute as it relates to probable cause. So if you are believing that there's probable cause as to child enticement, I'm hoping that you'll be able to point as to which subsection of the child enticement statute you think there's probable cause for. If it's subsection B of that statute, which violation of Chapter 14 you believe occurred.
Yes, sir. Apologize. Sorry, Your Honor. Yes, Your Honor. Based upon the information that we received in the Form 4, as well as my discussion with law enforcement, it is my understanding that there is electronic communications between the defendant and the victim in this case that both contain photographs that are explicit in nature, along with conversations between the defendant and the victim in which the victim knew that he was engaged with a minor in this, and the conversations were telling the victim to delete the information in order that they would not be caught. So with respect to 1430, Your Honor, I do believe that there is probable cause to believe that the state is going to be in possession of evidence under A1 that there were, explicit photographs that were exchanged between the defendant in this case and the victim that would fit the statute.
Counsel for defense.
Thank you, Your Honor. I have read the Form 4 thoroughly, and I do, again, recognize and appreciate that at our level that we're here now, that there is a lower threshold for probable cause. It's going to be my respectful suggestion, Your Honor, that not only is there not a low level of probable cause, even under this new statute or the state's intention to proceed under 1430, respectfully, it's devoid of any probable cause for the following reasons. Specifically, comments by a state's counsel about my client knowing that he was engaged with a minor. I recognize that it does say in here that he said, yeah, I met her at church, I know she's 16. I don't have a problem with that. To delete the communications, that's not something that is considered under any part of 1430, the statute itself. When I read the probable cause, and of course I'm not privy to any conversation that the DCA might have had with any detective in the case, but I work with ICAC detectives daily, and while I could probably guess what they might have said, we don't have it here in front of us. Again, not being privy to it, it's not in the Form 4 statement. Even if they were not able to pull up 1430 in the computer database, they certainly could have talked about it in the probable cause statement itself. So as I read the statute, Your Honor, under A1 specifically highlighted by the state, using electronic communication device, performing an act in person or through a third party, or using a written communication to lure or entice or attempt to lure or entice a minor to basically send me a picture of your genitals or the female breast. When I read the Form 4, the best I can see is that the parents of the minor victim in this case supposedly took a video of some communications, but what the Form 4 is totally devoid of is saying the officer who was doing the investigation saw that video. There is nothing in here in the written portion of the probable cause statement about explicit photographs. Nothing about genitalia, nothing about breast. It's not even, those words are not even anywhere in this particular statement. And what I instead have is communication when the forensic interview was done. I mean, not even the victim at a forensic interview is saying anything like he solicited, me to send pictures, or he sent me a dick pic or anything like that. There's nothing like that in this probable cause statement. And we know that material harmful to minors is defined in our statutes. I think it's 3501. I don't see that any of that statutory requirement, or sexual contact, or even, again, the nudity. It does not say anything like that in this probable cause statement. And what is even more revealing to me is when the officer indicates towards the end of the last paragraph on 1, it would assist the police if we could get into basically the defendant's phone and look for photographs or videos. I understand that. Maybe they've served a search warrant. I fully expect they're going to serve a search warrant. But at the time this was put together, they didn't have it. And it's not indicated anywhere in there. And the statute's very specific about asking for a depiction of the person's genitalias or female breast. We don't even know if it's something that would have come from my client's phone to theirs. I mean, that is just totally devoid of being mentioned at all anywhere in there. For all those reasons, Judge. And again, some of the things she said in a forensic interview, like we were talking, but we specifically said we're not going to have sex. We have to, I have to get your parents' trust, all that kind of stuff. It seems to, cut against what we are used to seeing in these types of cases. Usually in a forensic interview, if there is some sort of damning information, I'm used to seeing that. I just don't see it here. So for those reasons, Judge, it's my respectful suggestion. There is not probable cause, even at a lower threshold for initial appearance, to hold my client on ARS 13-1430, and I would ask for his immediate release.
Thank you, counsel. All right. So defense counsel stated the same concerns that I had under 13-1430 subsection A1, and that's why I did want the state to help us understand which subsection they were alleging here. Under A1, it specifically says that the defendant would have to lure or entice or attempt to lure or entice a minor to distribute a visual depiction of a person's genitals or female breasts. So in the most generous way of me reading that, it would be that the minor has to send a picture, she would have to distribute a picture to someone, it sounds like. The minor would have to distribute, but she would have to be doing the distributing of a visual depiction of a person's genitals or female breasts. So I suppose not technically hers, but she would have to be the one, the alleged victim, by my reading of the statute, would be the one who would have to be doing the distributing. There is some evidence or conversation that images were exchanged, sexually explicit images are exchanged. I don't know what sexually explicit means.
Right.
I don't know that that would be of someone's genitals or female breast. And even if those were exchanged, if the evidence is that the defendant is sending those to the alleged victim, that is a crime. Furnishing harmful items to a minor is a crime. It is not the crime that the defendant has been alleged to have committed. So for those reasons, for today's purposes, I'm not finding probable cause to support those allegations. Sir, I did tell you already that I am still appointing you an attorney from the Public Defender's Office out of an abundance of caution. The state can still pursue charges in this matter, so I am still appointing an attorney. I am still going to set some court dates for you on February 3rd and February 7th at 8:30 in the morning in the downtown Superior Court. But otherwise, as to this matter, you're going to be released without condition. I will note for the record, I did also review the victim's impact statement, but because I have not been able to find probable causes to this matter, I can't issue any sort of release conditions at this time. So, sir, I am intending to release you without condition, but please keep in mind those court dates. Anything further from counsel for the state?
Nothing further from the state, Your Honor. Thank you. Thank you, defense counsel.
Thank you. Counsel for defense.
Judge, I'm so sorry. I did not get the court dates, and if you're not going to do a release order...
We'll still do a release order.
Okay. As long as it's on there for me.
On there. Yeah.
And I have fully explained to Mr. Monroy the process. He's probably going to be contacted again, so I appreciate you still having an appointed attorney, but I did explain all that to him.
All right. So if Mr. Monroy, just give me a moment. If you want to talk to your client, you're free
Real
to
briefly.
do that.
Thank
And
you,
then
Judge.
we'll print out this release order. All right, thank you, counsel, for being here.
Thank you, Judge.
Thank you, Your Honor.
Have a good one. Thanks. Okay, so if we can print that and then we'll just handwrite the correct code up there, I think, so that should work.
Yeah, I told them they just hang out there because they know people get released and they don't have their phone. So we're just sitting there waiting. So you want me to tell her to get a hold of her, else to come pick your ass up for you. I mean, I can't imagine anything my wife.
Thank you. Do you happen to have Play-Doh?
If you were going to
Thank you. And then we'll have to, I guess, make copies for him, or you could scan it, I guess, copy. Okay. Okay, cool, thank you.
right now, you do have a you're not without protection. Just see me again, I'm sorry. Okay? Questions? All right, bud. You're very welcome. Just follow his directions.
Okay, I think that looks good. Thank you, I'll make that copy in just a second.
Thank you.
All right, otherwise this should conclude the 2 p.m. initial appearance calendar. The court will stay in a recess until 5 p.m. Go do that. Listen, I'm out on the 1st. I'm moving on the 1st. I'm very excited. Although I told Judge Welty, transfer me on April 1st. Is that a joke or am I actually here?
See you.
I think you'll probably always send us like release the play on them. I can know it. Yeah. And then release from there. Yeah.
All right, have a good one.
You too.
Bye. Hey, hold up, I'm gonna. Sorry, it's going to take a little longer. We're gonna leave that to get up for 5. Okay, sorry.
Thank you, sir.